Hi AI class, it's Professor Opderbeck, and in this lecture I want to give you a little bit of an overview of the EU AI Act, which is one of the main sources that we're going to be looking at this semester. Now, as I mentioned in the introductory comments that I sent to you, this is a really important source because of something we call the Brussels effect, which is in a number of areas in privacy and data security and online regulation, antitrust. It's been the case for quite a while that the European Union has been kind of one of the first movers of adopting comprehensive responses or comprehensive regulatory frameworks. And we certainly saw that in privacy with the GDPR, the General Data Protection Regulation. And privacy really was the driver of kind of global privacy compliance and remains the driver in other countries as well as in the US, both because many companies have to comply with the GDPR because they have European data subjects, and also because various US states are adopting privacy laws that are modeled on the GDPR. So we are seeing, or we think we are seeing, something very similar now with AI, because the EU AI Act is really the first comprehensive AI law that any kind of significant country or territory has adopted. Now, as I mentioned in the materials that I've already sent you, and that we'll be looking at throughout the semester, there has been a lot of discussion about exactly what the EU AI Act should look like, how it should be applied, and whether some of its provisions, which have yet to fully come online, should be modified. And really, just as of November of 2025, there has been a proposal put forward by the European Commission to make some modifications, some of which could be significant, including some delays in implementation. We'll talk a little bit about that when we do this overview. And we also, throughout the semester, will talk about what some of those may look like. So I do want you to keep in mind as we go through the semester that the EU AI Act itself is still very much in process. It is in effect, but it is not yet fully implemented, and we have yet to see what it actually will end up looking like as it gets applied. So a couple of things I want to point out in this overview, just in looking at the recitals, and I mentioned in the materials I sent to you, the EU lawmaking process and the laws that come out of the EU can be a little bit unfamiliar to us American lawyers, particularly in the kind of ponderous length and degree of explanation and other things that go into these sources. So yeah, they're long recitals and many of them, and it can be really tedious to read through. But they are important to interpreting the Act, and I want to point out a couple things. And these recitals 4 and 5 are just giving some thoughts about some of the potential risks and potential benefits of AI. And I don't think you'll be surprised by any of these, but AI can provide a competitive advantage and can provide personalized solutions and can solve a lot of problems. And at the same time, AI can harm fundamental rights, including things like privacy and safety and security and economic security and other things along those lines. So part of the effort at this regulation is to try and get closer to balancing out some of those potential risks and some of those potential benefits. Now, it's interesting to look at the AI Act's way of defining what it claims to be regulating. A bunch of the material that we're looking at in this first unit is actually trying to help us understand what is it we mean when we talk about AI. What is AI? What are we actually regulating? And the EU AI Act has some particular ways of thinking about that, and one of the things I really want you to notice that it focuses on is this idea that a machine learning system, an AI system, can make inferences, can infer. And then secondly, that it can operate with different levels of autonomy and various levels of adaptiveness. So this is meant to try to distinguish what we're talking about as AI and an AI system from kind of classical, what we might call classical computing. Classical computing is we have some things that are hard-coded in the code, and the computer is going to run that code, and that code is going to respond to different inputs from the user, but it's going to respond in very defined pathways. It's not going to be able to take kind of a general query and make inferences from that query about what the user might want, even if the user isn't explicitly saying that. And it's also not going to be able to operate on its own or to learn things and change and develop as the user is using it. Now, you should notice from this that given these kinds of definitions, actually AI has been with us for quite a while. We can really go all the way back to the 1950s or so, not only for the general idea of AI, but for the effort to develop systems that do some things like this. And for quite some time, we've had some computer systems that were, at least in part, able to do things like make inferences and learn and adapt. But we haven't had it at the speed and at the scale that we now have it. So digital technology, the massive increase in computing power in the cloud, the massive increase in storage power, and different computational and mathematical techniques for processing that large amount of data has really dramatically leapt forward the ability of this technology to function in these ways. Now, I do want to note something about this in this recital 12, which is this idea of inference. And you'll see throughout the semester, this is a real interest of mine as someone who's kind of, philosophically minded as well as legally minded. And I think it's a real kind of interest as the technology develops and as we talk about it in a broader social setting. So does a machine learning system really make inferences? I actually would push back against that. To me, an inference has something to do with a reasoning process that is, more aware and reflective than I think even the most powerful current machine learning systems are. So it's doing something, I would argue, that's analogous to human inference, but that isn't really inference, but that's the idea in the act. In some of the materials we're looking at this week, we're talking a bit about the difference between weak AI, strong AI, general AI, sentient AI, things like that. What we're talking about for this regulation are stronger forms of AI, but they are not anything like sentient sort of AI systems, which simply, as far as we know, don't exist yet, which may never theoretically be possible to exist, or which might be. We don't really know for sure. I guess we'll find out. Now notice also, and we'll when we look at the structure of the regulation, this will become important, this definition of general purpose AI. So you will see that the regulatory framework is a risk-based framework. It's talking about higher levels of risk, limited levels of risk, lower levels of risk, and then it's kind of got this separate category of general purpose AI, which is presuming a certain level of risk. So general purpose AI includes a model that is trained on large amounts of data using self-supervision that is capable of performing a wide variety of tasks and being applied to different varieties of things. If you look at this definition, you should be thinking about the things that are kind of often at the top of our mind and often in the news, like ChatGPT, for example. These large language models, these large image models that OpenAI or Google or other large entities have been putting out there that are really making kind of huge strides that people are using in different ways, and that then can be taken and put into different domains. So think of a general purpose model as these large-scale models that can be applied to a number of different categories. And as we go through the class, remember that general purpose AI is not the only kind of AI that matters. There's lots of AI that wouldn't necessarily be general purpose AI that still might fall into some of the other regulated categories. So as we just said, the overall scheme of the statute is risk-based. And this is very much consistent with the EU's approach to privacy in the GDPR. The GDPR is not, advocating for absolute privacy and everything for everyone all the time. That would be impossible. The world couldn't function, business couldn't function. So the question is, what's an acceptable level of risk? And in this, actually, the GDPR is mirrored on other EU regulatory law. For example, different kinds of product liability laws. And in the EU, those tend to be more kind of a centralized regulatory structure that lays out testing and certification requirements and then has different kinds of liability type provisions. So we can't have a perfectly safe automobile, but we can have one that's reasonably safe. And what does that mean? What kind of safety features would you want to have? Similar kinds of idea works its way all the way through cybersecurity, privacy, and AI. So when we look at these categories, there's a category of unacceptable risk, of certain things that are simply prohibited under the regulation. We're going to get into those in more detail in our next unit, but we'll talk briefly about what those are. And then there is a category of high risk, and these are things for which they're not prohibited, but there are some specific and somewhat more burdensome regulatory requirements. And notice the requirements that we list here: transparency, explainability, fairness, privacy, safety, accountability, and so on, follow the models of AI ethics that we are looking at in this first unit. Again, this is going to be very similar to the way the EU has done privacy regulation. In privacy regulation, it really begins in the 1970s with the Fair Information Privacy Principles, the FIPS. The FIPS lay out a general set of principles that are kind of ethics-related principles that tie into human rights concerns, and then the regulation builds on those. So similarly here, people have been talking for a while about these ethical frameworks around transparency and explainability and the like, and now the regulation is putting into effect ways in which the provider or deployer has to demonstrate that the product, that they've thought these things through, and that they're taking certain steps to mitigate risks that might be presented. All right, the limited risk category will be less burdensome types of things, and for those in general, the main obligation is going to be a transparency requirement. And transparency here is going to mainly mean the user is being notified that they are interacting with an AI system. And again, in a moment, we'll mention briefly what that category includes, and we'll come back to it throughout the semester. And then minimal risk would really be unregulated. We'll talk about that in a moment as well. That's going to be, I think, a relatively small category. The overall obligations under the EU AI Act are going to fall on a number of different parties. And here you've got to get a little bit of the nomenclature that the EU is using. So a provider is someone who is developing the AI, programming the AI, training the AI, so on, right? A deployer will be someone who is using the AI. Now, it's perfectly possible that the provider and the developer is the same entity, but you can easily see that it might be the case that it isn't the same entity. So think of ChatGPT again as an example. If you go to the interface that ChatGPT provides and use it, well, ChatGPT is both the provider and the deployer. If you are a company that wants to use the ChatGPT engine for a document management system or a document creation system or a user chatbot or something else, then you might be the deployer of the system. This again is very similar to the framework for privacy under the GDPR. Under the GDPR, you have the idea of a data controller and a data processor. A data controller is the entity that is collecting and using and doing something with the data, and a data processor is performing some operations on the data. And similar to the GDPR, there are different duties. Both controllers and processors have duties. The duties are somewhat different, although related. Similarly here, and we'll get through this, into this during the semester, the responsibilities on providers and deployers are somewhat different, but also somewhat related. We also then have categories of importers and distributors who are selling AI products or who are bringing AI systems into the EU, product manufacturers who are making certain products involving AI, an authorized representative who might be selling AI, other people who might be affected by the AI, and all of these will have some different obligations. The main ones we'll focus on during the semester are the provider and the deployer, but keep in mind these other categories as well. Now, this category of importer, distributor, and so on will bring up another important piece about the EU AI Act, which is it is an EU regulation, which means under the international law principles of sovereignty, it applies within the member states of the EU. The EU, of course, is not a political union in the same way that the United States is. The EU is not its own sovereign nation, but it is a treaty-based organization of sovereign states. So the sovereign states that have agreed to those treaties, right, this law applies within them, and it can't apply extraterritorially. But what extraterritorial means is an interesting question in international law, particularly as we apply it to things like GDPR and now the EU AI Act. So under GDPR for privacy law, the GDPR says that it applies whenever anyone is processing the data of an EU data subject, which includes an EU citizen and some other categories of things. So even an EU citizen who happens to be physically in the United States, if you're processing their data, the position of the EU is that the GDPR applies to you. Even if you are a company that's based in the United States and you're using cloud-based servers that are not based in Europe, and you are processing data of European data subjects, the EU asserts that the GDPR applies to you. Similarly, with the EU AI Act, the EU says if the AI even if the AI system is used outside of the EU, if the output of the system is used within the EU, the EU AI Act still applies. So it can have a very broad potential extraterritorial effect. There could be some debate in international law about exactly how far that should apply or not. We haven't seen tests of that really under the GDPR, I think for a number of sort of practical reasons. It's probably something that's not worth testing and more worth complying with if you need to. And the same probably would be true of the EU AI Act. But realize that this Brussels effect includes not just the example of making the law, but the fact that because the EU is such an important global market and an important global trading partner, including for companies in the US, there are going to be compliance obligations that have to be thought about. So some other overall frameworks of the regulation. It establishes EU-wide and national level AI regulatory authorities. This again follows very much the pattern of the GDPR. The GDPR established an EU-wide privacy regulator, and then within each of the EU member states, France and Germany and so on, there's a national level regulator, and there are domains of authority and enforcement authority and adjudication authority that those regulators have. Same thing with the EU AI Act. We will again get into this more as we go through the semester. And you can see in one of the materials that I gave you to look at this week that really the member states are just beginning to kind of stand up what their national authorities are going to look like and exactly what their responsibilities are going to be. Now, the regulation itself went into force in August 2024, so it is presently in force. But notice that only the prohibited practices are currently in effect. There's a rollout period within the regulations. The prohibited practices and I should say the GPAI rules, and we'll talk about those again as we go along. Now, an important thing to notice, August 2nd, 2026, next summer, was supposed to be the day that the high-risk rules go into effect. Those rules, as you will see through the semester, are really kind of the most extensive and potentially burdensome and potentially widely applicable parts of the rules. And they're very much parts that have been contested and talked about and pushed back on. One of the things in the current package of modifications is a proposal to put that date off. And it's very likely that most, if not all, the proposals in that package will be adopted. Very likely that date will be put off, probably until December 2027. But we'll have to wait and see. Probably sometime in the middle of our semester, we might even find out kind of what the exact status of that is. August 2027, the specific compliance rules about aspects of GPAI, general purpose AI, will go into effect. And then August 2027, rules about AI that are part of a regulated product. And we'll talk a little bit about what that will mean.